Earlier this week, I attended a reception in Washington, D.C. with nearly 80 other marriage plaintiffs, some of who, like me, have lost their loved ones. The event was the evening before the Supreme Court oral arguments, and I feel so proud to be a part of a group of people whose stories have shown America that it's time for the freedom to marry. On that quest, we have had the support and leadership of two remarkable women. Mary Bonauto and Robbie Kaplan know our stories because our stories are their stories as well. Both of these brilliant, strong out women have represented us before the Supreme Court. And as a proud out lesbian, as a plaintiff for marriage equality, and as the wife of the late Carol Goldwasser, I am so thrilled to introduce them to you tonight. Ladies and gentlemen, please welcome to the stage Mary Bonauto and Robbie Kaplan.
Well, I will start off by saying my goal is to talk very, very little, but I will share a story with you just because I think it fits within the larger conversation we're going to have tonight. So when the DOMA decision came out, I covered Wimbledon for ESPN, so I was overseas. And I got the little message on my phone and was immediately overcome with emotion. Tears flying, the whole thing. But I'm in this environment covering sports, surrounded by pretty much all heterosexual. No one really cares what happened. And so I went out to the hall where I was able to sort of just let the emotions flow. And who do I see coming down the hall but Martina Navratilova? And we looked at each other. We didn't say a word. We just ran towards each other like kids and just hugged for a while. And we both just let the emotions sort of pour out of ourselves. So with that being said, that's me over in London. How did you feel?
Well, you know, it was we were waiting in my apartment, and the Supreme Court, unlike any other court or most other courts, has this strange policy where they don't really tell you when the cases are coming down or which case is coming down. You only know that on certain days the court's going to issue opinions, but you don't know which opinion it's going to issue. So we had this fire drill, I think on at least 3 occasions, where we met in my apartment. We kind of all sat around with Edie, sat around the dining room table and waited, like everyone else, logged on to SCOTUS blog, waiting to see what decision they were going to issue. And I can't tell you those were the funnest 3 occasions of my life. They were very frustrating. Edie in particular was understandably not a happy camper about it. So by the last time, though, we knew that that was the day. That was the last day they were going to issue decisions, so we knew our decision was coming down. And we were really looking for 3 things. We were looking, one, to see whether it would be the first decision of the day, because Perry was also going to be released that day. And because of Supreme Court protocol, we thought that if our decision was issued first, it was probably written by Justice Kennedy, and that was probably a good thing. So 1 is Windsor 1, this is the first case. 2, is it written by Kennedy? We saw those 2 things pop up across the laptop screen. And 3, it said dissent by Scalia. And when it said dissent by Scalia, that was it. We knew what had happened. No one had to read a word. And pandemonium really broke out in my apartment. I mean, there were incredible tears, incredible screaming. I was probably doing both. My wife, I remember, cried and said, the whole world's going to be different for our son now. It was an incredible, incredible moment. And then shortly thereafter, the president called to congratulate Edie and us, which was also obviously an incredible thing. So it was not a bad day.
It was not a bad day.
I'll take it.
It was pretty good for me too, just so you know. Can you talk a little bit, both of you, can you talk a little bit about the emotions that you feel the day of you go in to have the arguments?
I'm going to let Mary go first because she's done it.
She's pretty fresh.
Raw for her,
yes.
Exactly.
Well, when I realized I was going to be presenting the arguments, you know, it's obviously a complete, tremendous honor and privilege to have that trust and to feel in my bones like the millions of people for whom this matters. I was also terrified when I first thought about it, like, oh no, they're going to be so annoyed about the last 2 years of everything that's happened since Windsor, which was true. At least some of them. But you know, I went into this with so much support. I mean, it couldn't have been better. And I say that not only because, you know, there'd been this 2013 round with Robbie and Windsor, which, you know, took us so far, and also the whole Perry team and what they accomplished and the education that came out of that. But then, you know, we had four cases with 4 sets of briefs and like a zillion amici briefs, which were all awesome and incredibly reputable.
At least the ones on our side.
On our side, yeah.
Right.
The other side was really...
Not so much.
It's kind of like somebody should write a good story about that.
I'll write that down.
Yeah, please. Seriously. And then in addition to all of that, the legal teams were incredibly supportive of me, and in particular, Freedom to Marry, Lambda Legal, the ACLU, and National Center for Lesbian Rights were like right there with me, trying to really think through everything to make sure that this was as strong as it could be. You know, I had just so much support, and I was really very aware of what I was carrying. So yeah, I was terrified, but I also felt like, you know what, damn it, we are right. We are right, and they have got to hear that, and they're going to hear it from me. So I felt good. I felt good. Yeah.
I know you felt good, but your trip to wasn't as smooth. Could you explain a little bit about what happened the day of?
Yeah, well, I'm just gonna like come clean here, which is like I am a little bit sartorially challenged. So like I bought what I thought was like a really nice suit for the Supreme Court, but our press person said no. And this was Plan B, by the way, in case Plan A didn't work out. Okay, so anyway, I got a new dress, and then she had the makeup person come. I was like, I don't wear makeup. Anyway, so I went, well, makeup. So then, like, I get through the whole makeup gauntlet. I've got the right dress on. You know, we get into a cab to get to the court. I think there's plenty of time, but it turns out our cab driver does not know how to get there, and he drops me off at a federal office building, which is not the Supreme Court.
Way.
Yeah, I was like, this is not the Supreme Court. I know that. I've been here before. So, you know, we're all like on our phones, like trying to figure out how to direct this guy to get to the Supreme Court. And then he hits this major traffic jam. And I was like, we're out of here. Let's go. So jump out of the car and ran to the Supreme Court. So if you see pictures of me like this, it's because the reality was we were truly running to make sure I got there on time. Anyway, so day started with a bang.
They have this crazy thing, before you argue at the Supreme Court, they have this, it's a very formal place, as you can imagine. It's got a lot of traditions. And so one of the traditions is, if you're arguing, you go into this room called the Lawyer's Lounge, and you get this lecture. When I was there, the man's since retired, but by this guy named General Souter, who kind of tells you things about the court. And I've heard him do it a number of times. And a couple of things he says, and I've heard him do this, is one, you know, that you have pencils. If you need pencils, we'll give you pencils. We have cough drops if you need cough drops. If you need a sewing kit, we have a sewing kit. And every time they said that, I remember thinking to myself, I don't care like if every single button falls off my blazer. Like if they think I'm going to sit here and sew buttons on with a sewing kit. And then a friend of mine who's argued suggested that I put on my makeup in the ladies' room in the Lawyer's Lounge. And I only thought to myself, if I did that, I will look like Chuckles the Clown from Mary Tyler Moore. Like, there's no way I can put on my makeup in that room. But it's obviously the stress is incredible until kind of you get out there.
Can you talk a little bit about what it's like to actually present the argument, right? Like, could you read any signs from the justices? Could you tell when you said something that resonated versus something that went completely over their heads?
Well, why don't I say a little bit about the argument, although you have to understand I need to speak at a pretty high level of generality because the case is under consideration, and I don't think they'd appreciate a lot of detailed analysis from me at this juncture. So with that said about the argument, I mean, the deal about oral argument is ideally you're moving your ball forward, right? And you don't want to concede anything. That would be damaging, and they're definitely going to press to see if you will concede something that's important to your case. But the major thing that's going on in oral argument is they are testing different theories, trying to explore those, so that's certainly part of the questioning. And another part of it is that they're talking to one another, and the ones that they may be trying to persuade to go along with one side or another. And there's definitely, I think it's a fair interpretation to say that there's a fair amount of that going on as well. So that's some of the backdrop. And then for my first part of the argument, you know, we had We had questions about 1,000 years, or millennia, more than 1,000 years of male-female marriage. And, you know, what is that all about? And I don't know if you remember the cases from the 1970s, which were, you know, treated so dismissively. And the idea for those cases in the 70s was, well, marriage just by definition, what marriage is a man and a woman for purposes of procreation. So here we are, you know, in 2015. Is marriage just a man and a woman? And, you know, Michigan was arguing it's for the purposes of procreation. So there's a way in which we've sort of come full circle here. So you had that kind of thing. You had a lot of wait and see, because again, this is a case that's not just about the states with amendments or the states where we don't have marriage right now. It's about all 50 states. So wait and see. You know, Chief Justice Roberts asked me about Maine. Perhaps knows I'm a Mainer. And you know, Maine went one way and then it went the other. And I said, yeah, it's because it didn't have any amendments, like all these other states do. So, you know, there was a whole wait and see piece. There was a lot of concern about consequences, potentially, you know, polygamy, and when we got into Michigan's argument, you know, non-marital birth rates rising, and, you know, all kinds of other speculation and so on. There was definitely religious chatter. I shouldn't say chatter. There were questions about the impact on people's, on religion, on would ministers have to marry. Justice Scalia hadn't, well, I'm sorry, I'll stop. About ministers marrying people, about religious schools and would they have to extend married student housing. Would it be possible to take away the tax exemption of a school that you know, didn't support marriages? So there was a lot of that kind of thing going on, a lot of testing, and they came at me hard, but they also came at Michigan very hard, different people. So anyway, I guess I want to say this. I don't think anybody, you can't read too much into the questions. It doesn't tell you what's going to happen in the end. I certainly feel that it's, you know, nothing is ever a sure thing until it's done, but I certainly think there's reason to feel hopeful and feel optimistic.
The Supreme Court has many things that are unique, but one of them is that you're actually very close to the justices when you're arguing. You know,
like how close? What's very close?
Like Chief Justice Roberts, if you're arguing, is about where the edge of the stage is. I mean, really, you're right on top of the justices. So you can really see them, sometimes too clearly, but very clearly. And I had been given, I brought into, in addition to Mary and the ACLU and all these other people in our case, I brought into our team a very brilliant constitutional scholar, also an open lesbian by the name of Pam Carlin. Yes, who had argued many cases at the Supreme Court. And one of the pieces, many great pieces of advice she gave me was, when you're arguing the case, she said, look to Justice Kagan, who sits all the way on the right. She said, because Justice Kagan is very astute, and whatever questions she asks will be a signal to you as to which way the court is going or not going. And so you should pay very close attention to what she says. So when I was arguing the case, she actually didn't ask me any questions. Most of the questions I got were from the chief right in front of me. And there were times when they got a little heated, as they did with Mary. And however, during the questioning, I kept looking to my right, following Pam's advice, because I always follow Pam's advice. And every time, now this could have been totally in my head. I could have been hallucinating. It's possible, because I'm known to hallucinate. But every time I looked to my right, she seemed to be smiling. And so I remember thinking to myself, to the argument at least 2 or 3 times, so Kaplan, like, you haven't screwed this up yet. You know, Kagan's still smiling, must be a good thing. And it's amazing the degree, again, it could not have been based in reality at all, but it's amazing the degree to which things like that can have an impact on you just, you know, in the moment.
Speaking of advice, what advice did you give your colleague?
I sent her an email. I'm trying to remember it verbatim, but I basically said, which is true, that Mary owns this issue. That no one knows this better than Mary, that none of us, not one of us in the United States of America would be married today but for Mary Bonauto, who brought the first cases in Vermont and Massachusetts. And that Mary needed to show that to the justices, and she did.
And what lessons did you learn?
From watching Robbie and you know, to be fearless and forthright and to speak the truth, which she did, I think, exquisitely well. And Although I was in a defensive posture a lot of the time, I came right back with those kinds of points as well.
Now, you had an interesting strategy for your case in which you told your client not to talk about sex. Can you explain to us why?
Yeah. So probably many of you at this point have met Edie. So I don't really have to tell you the story if you've met her. No. So Edie is an incredible, obviously an incredible human being. At this point, she's a member of my family. Brilliant woman, incredibly charismatic, incredibly beautiful, incredibly articulate. At one of the first press conferences we had, James I'm sure remembers this, when we filed the case, there were two young gay couple there, and they said to her, they asked her advice, what's your secret to staying? She was with Thea Spire for 44 years. What's your secret for staying together so long? And Edie proceeded to give an answer that began with keep it hot, and then went on from there. So one of the deals, we had like 3 rules in the case for each other. 2 of them were for her, 1 was for me, but one of the rules that we had was that she couldn't speak about sex that way until we had a decision. And I said, once we have a decision, all bets are off. You can say whatever you want, and she kept to that promise. She has definitely done that. But the reason was I really didn't want, I wanted her image to be a certain way, and I didn't want the conservatives to be thinking of her in kind of sexualized terms. I mean, it's a shame in a way, but when you're arguing for the Supreme Court, you have an audience, and that audience is the 9 justices of the Supreme Court, and that's the audience you got to worry about. It's not really, that's what matters. Those are the votes that count. And so I think the joke I said to her is I didn't want Justice Scalia, reading about her escapades in the village. I'm not going to get into too much detail, but when she and Thea were young. And she held me to that, I held her to that promise, and she held me to my promise, so it worked out.
How difficult is it for you, especially as strong women, to sort of curtail that in, if you will, to present an image that's more palatable to the larger society?
Well, for me at least, in some of with this Michigan situation, I didn't have anything to do with selecting these clients, but I will just say, give a real shout out to these women, April DeBoer and Jane Rouse, who have had 5 children placed with them by the state of Michigan, and all kids who were in severe distress, who are now healthy and happy kids who I have met. They are incredible. So I didn't really pick them, and I feel very fortunate that I had the opportunity to represent them and that they are part of the face of this. But when I brought cases previously, and again, it feels like a really different era, and it was. In 1997, filing in Vermont, and 2001, filing in Massachusetts. We were trying to do the kinds of stuff that people in this room have perfected, right? How do you make somebody human and accessible and see them at their kitchen table? I was always spending time at people's houses trying to figure out what the camera shots are going to look like. And, I didn't make anybody make pancakes, but the press always seemed to want to do that. So anyway, I always just look for people who were a variety of people, so that were different spokespeople, who were somewhat different from one another, and who I thought could stand the rigors of the press and the intrusion in their lives. And again, another goal I had was to make sure that they would stay together during the case, because I didn't want those separations to be occurring in the middle of a case. And here's the thing, in terms of like what you say and whatever, I mean, the key for me has always just been like authenticity. Like, do you feel and sense that they really love and like one another? And that they really can talk about why marriage matters to them. And they may not call it the way like the Mass Court did, a scarring hardship or something. But you want them you want to sense both that joy that they are waiting to partake in, as well as the real, genuine, soulful deprivation that not having marriage imposes on them. So for me at least, the process of interviewing plaintiffs is, unbelievably time consuming, but worth every bit of it. And with Edie, I feel like we couldn't have been luckier. But I feel very, very grateful to every single person I've ever represented for really having this enormous courage to put themselves out there and tell their story at times when people didn't really want to hear their stories so much.
Yeah, I should be clear. We had the rule about sex. We had only two other rules. One, she could never, for a time she used to want to say that she didn't care about getting her money back, and I said, no, 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 no. When you file a lawsuit, you're filing a lawsuit because you want your money back, so you want your money back. And then the third rule is I wasn't allowed to refer to Thea as her spouse, as her wife, only as her spouse. But that was it. I mean, one of the things that made Edie such an incredible symbol in our movement, such an incredible plaintiff, is how much her story really told the story of our people over the course of the 20th century, and the way she lived her life with Thea, really in sickness and in health, as we just heard from the woman before, till death do us part. I mean, really told, I think, in very visceral terms, the dignity with which gay people live their lives. So those were the only rules. I said, you can pretty much say anything else you want, and she did, and she was great at it.
There's one of those great little-known stories about Rosa Parks and how the narrative that is taught in school is about how she was this tired seamstress that just didn't want to, stand up and couldn't make it home and needed to sit down, when in fact that was not true at all. She was a long-term NAACP activist, and it was sort of, she was positioned to do exactly what she did. But there were people before her, a young girl in particular who was a young mother, teenage mother, wasn't the perfect client. Movement did not think she should be the person who should be the face of that particular argument. Did you have to turn people away because they didn't quite fit the narrative that you needed to get us forward? And if so, what was that like?
Yeah, no, I've had that experience many times where, again, it's like everybody's good at some level, right? Everybody's good. They care about this issue. They care about their partner, so that's all good. But for me, it's like I could explain to people, I'm looking for media markets. You're not going to be available. Or sometimes it was clear from talking to people that it was just going to be too much for them.
What were the indicators?
About it being too much for them? When you start having conversations about, tell me about times that you've had a lot of stress in your life and how you manage it. And it's clear that their lives blow up when they have a lot of stress. That's not a good sign. So sometimes just in the court, because I would explain, I can't predict exactly everything that's going to happen here. And I thought I was really far-seeing with both Vermont and Massachusetts about how hard it would be, but it was harder both times than I had predicted. So anyway, it would be that kind of thing. Or sometimes, frankly, when getting into criminal convictions, depending on what it was, that would be something that somebody wouldn't feel comfortable having out there, and I couldn't guarantee it wouldn't get out. Didn't necessarily disqualify them, but how they felt about it would be another matter, that kind of thing.
Yeah, we've been talking tonight about the stress of arguing and litigating a case like this, and clearly there's plenty of stress involved, but what we haven't really talked about, although you heard Mary allude to it, is the stress on the plaintiffs. Even for Edie, who really was just a single plaintiff and who we won at both courts, and I think her life was pretty good during most of the case. It's stressful. Those 3 months when we were waiting for the decision were really, really hard on her. And so you want someone, obviously, who's ready for that. And I don't know if you'd ask Edie today if she would say, I'm sure she would say she was ready for it, but I don't think she anticipated how stressful it would be.
Yeah.
Did you know how stressful it would be for you?
Oh, I've been doing this for many years. I know exactly how stressful it would be for me.
But this is history. This is one thing to argue for your corporate client. It's something totally different to have an entire movement rest on your shoulders.
Yeah, no, I certainly never knew that. Obviously, it's like kind of, winning, it's like buying a lottery ticket. I had no idea that was going to happen. I kind of like stress. It motivates me. I think when the justices kind of got irritated with me during the argument, it kind of motivated me. That's kind of the New York way I live my life. So for me, it's probably a motivator. Probably for not a lot of other people, but it's probably the impact it had.
I mentioned Rosa Parks earlier, and oftentimes people make the comparison between the African-American civil rights movement. Can you talk a little bit about what you see as litigators are the similarities and what are some of the differences?
I think in both movements there's been some attention to trying to think about working incrementally and building up. I think there wasn't quite the same emphasis about moving in state courts in the African-American civil rights movements. So that's one piece of it. The other thing is, I think allies have been super important in both movements. And this room, and the support that has come out of this room and others to the organizations and the plaintiffs and so on has been profound. And I certainly know that there were law firms and others who were providing support And you need that, because you're just too small as this minority that's like, trying to climb this huge mountain. You need support, you need other insight, you need that encouragement. So I think those are things that are there. And on the marriage issue, it's so funny because obviously in both movements, I'm not trying to say that they're entirely separate, but in both, you had to deal with marriage. But I feel like with us, marriage is central to the discrimination that we face, because it's about relationships, and our relationships are what people object to. And I know it's relationships, there are plenty of people who object to, relationships so-called across the color line as well. I totally get that. But there were so many other visible, visceral ways in which people were being so obviously oppressed by law, with respect to, schools and Jim Crow and everything else. So there are differences too. I'm not saying we don't have those issues, we do. But it's one thing to be ignored, it's another thing to be affirmatively told you must do something separate. So anyway, I see both.
We were very sensitive in Windsor in not making direct comparisons to the African American civil rights movement. And we felt very strongly about that, and we believe that because while there are certainly similarities, the differences are profound. As bad as it's been for gay people in the United States, gay people never suffered through Jim Crow. They never lived through the kind of experiences, obviously, that African Americans have. And so we thought making that distinction was an important distinction to make, and you won't find comparisons in any of our briefs about that. On the other hand, I find probably the most moving thing that's really ever happened to me, or happened to me in the recent past, has been the change on this issue in the African American community. I first started doing this, I did the New York case in the New York Court of Appeals, again with James, in 2006. We lost that case. We certainly had African American support, but it was no way analogous to the kind of support that exists today. So the best example I have of this is in January and before that, around Thanksgiving, argued a case for the right to marry in Mississippi. And the judge who was assigned to the case is a guy by the name of Carlton Reeves, is the second only African-American federal judge ever appointed in the state of Mississippi. We thought it was a pretty good pick for us, and it turned out we were right, because when I was arguing the case down in Jackson, Mississippi, a city obviously where very important things in the civil rights movement happened, Judge Reeves asked me this question about Brown v. Board. Now, as you people probably know, after the Supreme Court decided Brown v. Board in 1954, they issued another decision in Brown 2 in which they said desegregation should happen in the South. The words they used was with all deliberate speed. What they meant by that is not so fast, don't rush. And the reason they probably did that was because of a concern that there would be such social upheaval in the South that it would really disrupt society. So I'm arguing this case in Jackson, and Judge Reeves said to me, Ms. Kaplan, what do you think about all deliberate speed? And I thought he meant what most judges mean when they ask that question. Again, I've been doing this for a while, so I said, oh, Judge, you don't have to worry about that. For God's sake, gay people are getting married in Utah, in Oklahoma, and there's nothing happening. There's no rioting in the streets. It's no big deal. You don't have to worry about that. And he said, no, Ms. Kaplan, you kind of misunderstood my question. He said, when I was in the first grade, I grew up in the Delta in Mississippi, and it was 1974. And he said, in my first grade class was the first ever integrated class in the Delta in Mississippi in my hometown. And he said, as far as I'm concerned, Ms. Kaplan, 20 years is too long. Of all the experiences I've ever had in courtrooms in my life, and I've had a lot, I don't think I've ever had an experience that moving before. I mean, here you have this African-American judge basically saying, in response to the argument, to the wait and see argument that Mary faced at the Supreme Court, saying, I don't think so. I don't think that gay people should have to wait and see the way African-Americans were forced to wait and see after Brown, and I'm not going to do that. So I hope I get another experience that moving in a court of law in my career, but I'm not sure I ever will.
We know there's an election coming up. We know there's been rhetoric from some on the more conservative side that have talked about passing an amendment to the Constitution banning same-sex marriages. Should we be concerned about that? How real is that to you?
What I know, I don't know. I don't know how real it is. I'm not surprised people are saying that. People could be saying that in 20 years too. I mean, some people are just going to say a lot of things for a long time. But having said that, it takes 2/3 of both chambers to pass an amendment out for ratification to the states. It takes 3/4 of the states to ratify an amendment. So you need 38. That means, do we have 13 states? In a worst case scenario, do we have 13 states where we could defeat an amendment? And happily, the answer to that is yes. I never want to get there. I don't want them to get to 2/3, but you know, we went through this in 04, 05, I think it was in 05 after Massachusetts. People got all ginned up about that, 04 and 05. And you know, we survived then when things were much, much worse. And it feels like they were much worse. You know, public understanding was not quite the same. And so anyway, I feel like, I guess I'm not saying there wouldn't be a lot of work to do to defeat something if somebody really makes a push, but I'm fairly hopeful that we would be able to do that and use it as an educational opportunity too, to really press people in these states who are advancing it to say, look at these families in your states and look at the joy that they have and look at the protections they have. And that's what marriage is so much, is protection along with dignity. And you want to take that away from people. I mean, I feel like good luck to these people. Good luck to these people who want to push that.
I agree with Mary. I don't think that's a major concern. I tell you what is a major concern, though, which is look how close our margin is on the Supreme Court, guys. We won Windsor by 1 vote. In I'm very superstitious like my Jewish grandmother, but assuming we win this case, it will also be by 1 or 2 votes. And that's not a very big margin for the equality of gay people under the law. Justice Ginsburg, who is one of my all-time heroes, otherwise known as Notorious RBG, is not exactly a spring chicken, nor is Justice Breyer. They will be retiring sometime soon. And I know this isn't a political event, but who the next president is going to matter incredibly much in terms of whether the court continues to honor the equal dignity of gay people under law. Because I'm telling you, there are 5 votes on that court to reverse it easily. So 1 or 2 votes really matters.
Are you applauding the reversal, or are you applauding the... And my last question for you deals with your own legacies. And I know as you're living your life, you don't stop in the mirror and go, my legacy. But if we can just have that moment, assuming things go the way that we think they will go, what would you like history to say about you?
Boy, I don't think
you definitely have to go first on that one.
Yeah, I don't even want to think. I'm sorry. I'm not gonna answer that question as though we don't know what happens at the end of June, because I don't know what happens at the end of June. You know, for me, I've been at my organization for 25 years. I have been really happy to be there in the weeds, in the trenches, doing the work, and you know, and partnering with so many people to do that work. Thousands and thousands of people. So frankly, if I have helped to not only like advance the ball on getting equal justice under law, but also show how what can be accomplished when people do work together, something that I know people in this room already know, then that's all good. That's all good.
I can't help myself. I am a New York lawyer, so I'm going to tell the story by giving you a story. So not too long after Windsor came down, our son, who is now 9, is obsessed with movies. And we decided we were going to have a family movie night. I told the guys at my table the story, but we decided, my wife and I decided that we couldn't handle another Disney cartoon. So we were going to insist that we got to choose the movie. We're going to all watch the movie together. We chose My Fair Lady. And we watched the movie, and my son loved it. And when the movie was over, he said he had 2 questions. The first question he said, I'm really not so thrilled about the fact that Eliza went back to Henry Higgins. He's like, he didn't treat her very well, so why did she go back to him? I have to say, I think as a mother, it was one of my proudest moments ever, because we clearly were doing something right. And then his second question was, he said, I guess this is kind of an old-fashioned movie. And we said, yeah, Jacob, it is kind of an old-fashioned movie. And he said, yeah. He said, I guess this movie was made before men could marry men. And my wife and I heard gasp. That's pretty much what we did at the moment. If I could have helped to create a world in which my son thinks that something's old-fashioned is because it happened before men could marry men, I'm pretty happy with that.
You know that, please join me in thanking these two brilliant women